Hello everyone. So today I would like to share to you about maritime injury lawyer and Houston T Act. Workers in the maritime industry face some of the highest risk of being injured on the job compared to other fields of employment. Maritime law recognizes the hazards that seamen and maritime workers face. The law provides them with rights to seek extensive compensation and benefits when they are injured or develop an occupational illness due to the negligence of their employers or the owner-operator of their vessel. For more than 25 years, the Houston Maritime Injury Attorneys of the Deckhand law firm have fought to secure maximum compensation for our clients who have been injured. We understand the difficulties that injured accident victims face when trying to get compensation from big corporations and their insurance companies. That's why we take a small firm approach. We limit the number of cases we take on so that we can give you and your case the full attention and effort you deserve. We bring extensive knowledge and experience to every case we handle. Founding attorney Michael S. Callahan has an engineering background and is a board certified in personal injury trial law by the Texas Board of Legal Specialization. You can trust that we have the ability to handle even the most complex offshore accident injury claims. Learn more about the compensation and benefits you may entitle to for your injuries. Contact our firm today to set up a free initial case review with the Houston Maritime Law Firm. Maritime law is comprised of several different federal statutes. Those statutes give people who are injured on sea vessels or in maritime facilities the right to pursue compensation when their injuries are caused by the negligence of employers or vessel facility owners and operators. Injuries on land. Injuries to maritime workers that occur at shore-based maritime facilities such as dry docks, cargo facilities, and ports are usually covered under the Longshore and Harbor Workers' Compensation Act. Injury in navigable waters. Injuries to maritime workers that occur on the navigable waters of the United States are usually covered by the Jones Act. Injuries to workers on sea-based facilities such as offshore drilling platforms are usually covered by statutory extensions to the Longshore and Harbor Workers' Compensation Act. However, there are a number of exceptions to these rules that depend on the type of vessel the maritime worker was on at the time he was injured. Injuries in the harbor. Depending on the exact circumstances of the accident and the injured worker, the Jones Act or the Longshore and Harbor Workers' Compensation Act may apply. The Jones Act, formerly called the Merchant Marine Act of 1920, provides legal protections and benefits under admiralty law to persons working as seamen aboard vessels who are injured due to unseaworthiness of the vessel or other acts or negligence that occur aboard a vessel in navigable waters. The Jones Act was intended to ensure that maritime workers received compensation when they suffered injuries or illness due to accidents or exposure on board the vessels on which they served. However, unlike a workers' compensation claim under Texas law or the laws of other states, the Jones Act provides injured maritime workers with a much broader array of benefits. Traditional state workers' compensation laws provide injured or ill workers with medical care for their work-related injury or illness. Those workers get disability benefits for permanent injuries and partial wage replacement if they miss time from work. The Jones Act gives injured maritime workers several other benefits, not all of which are available under state workers' compensation laws. Jones Act benefits can include medical care for work-related injuries and illness, living expenses during the period of recovery, lost wages, loss of future earning capacity due to permanent injuries and disabilities, compensation for pain and suffering, physical impairment, and mental anguish. Our Jones Act attorney have handled many of these cases, and our Jones Act lawyers are ready to help you. The Jones Act gives injured or ill maritime workers the right to file a maritime or multi-lawsuit to recover compensation and benefits for injuries and illnesses that arise when working aboard a vessel in navigable waters due to the negligence of the vessel's owner, operator, or another employee of the owner or operator. Because the Jones Act requires vessel owners and operators to provide seaworthy vessels, the statute effectively protects several important rights of maritime workers, such as the right to a reasonably safe work environment, the right to bring a lawsuit to recover compensation for injuries and illnesses caused by someone's negligence, the right to compensation for medical care, cost of return to shore, living expenses, and lost wages, the right to loss compensation if one's vessel is deemed unseaworthy, the right to punitive damages when one's employer refuses payment of benefits the maritime worker is entitled to. If you have a Jones Act case, contact our Jones Act Injury Attorney. The Longshoremen and Harbor Workers Compensation Act (LHWCA) provides workers' compensation benefits to employees who work on loading, unloading, crafting, and repairing maritime vessels. Maritime workers covered by the statute include longshoremen, harbor workers, ship repairmen, and shipbuilders. The LHWCA also covers some workers aboard vessels in navigable waters. The LHWCA obligates employers to compensate employees whose work-related injury or illnesses requires medical treatment, cause them to miss work, or necessitates vocational rehabilitation. So, the LHWCA also provides survivor benefits to the families of maritime workers killed on the job. Various federal statutes have further extended the scope of the LHWCA to other kinds of workers, including private employees working on military bases or other government property under contract to the government, and offshore drilling workers on the outer continental shelf of the U.S. Government employees and workers who are otherwise covered by state workers' compensation laws are excluded from the scope of the LHWCA. Workers who directly aid in the mission of a seagoing vessel are instead covered by the Jones Act. So I think that's all from me. I hope you guys understand, and thank you. Bye bye.